Not Criminally Responsible is the title of a recently released documentary in the Canadian Hot Docs Festival. This film follows the story of a man who attacked a young woman in a shopping mall 13 years ago. He was found not criminally responsible for his actions due to his mental disorder and was confined to a forensic psychiatric facility. This film includes interviews with doctors who treated him, as well as the police officers who investigated his crime and the victim and her parents. This film introduces many issues about the Canadian legal system, including victims' rights, public safety, and the rights of the mentally ill. This pragmatic film echoes many previous cases that have occurred in Canada and may play a major role in the future of the issue about people who are found to be not criminally responsible. Not criminally responsible means that the person responsible for the crime acknowledges the crime they committed, but they claim they were suffering from a mental illness at the time of the crime and therefore cannot be held responsible for their actions.
Section 16 of the Criminal Code of Canada states in part, "No person is criminally responsible for an act committed or an omission made while suffering from a mental disorder that rendered the person incapable of appreciating the nature and quality of the act or omission, or of knowing that it was wrong." The definition of the term wrong in Section 16 was debated in the case R. v. Chalk in 1990. The issue was whether or not the term wrong was restricted to meaning legally wrong, or did it extend to mean morally wrong as well. In 1985, Robert Chalk, then a 15-year-old boy, and a 16-year-old friend, Francis Morissette, broke into a Winnipeg home to burglarize it, bludgeoning and stabbing the home's occupant to death. A week later, they turned themselves in with full confessions. Psychiatrists gave evidence that both boys had paranoid psychosis, causing Chalk and Morissette's lawyers to raise the defense of insanity within its meaning in Section 16 of the Criminal Code. Nevertheless, the boys were both convicted of murder by a jury in the Manitoba Court of Queen's Bench. This conviction was later upheld on appeal, and the defense of insanity was rejected by the jury. In a new trial, Chalk was found not guilty by reason of insanity and sent to live in a mental institution. After 4 months of treatment, he was released and lived quietly until he was accused of stabbing his 2 neighbors in 1999.
Chalk's actions in 1999 raised the question of whether or not the mentally ill perpetrators of violent crime can be rehabilitated in such a short amount of time. Many have questioned, should there be a different punishment for people who plead not criminally responsible for their crimes?
For example, should mentally ill people who commit murder be given a regular 25-year sentence as the Canadian justice system enforces, but have them serve their time in a mental institution?
More recently, Richard Kachkar was found not criminally responsible for the killing of an on-duty Toronto police officer, Sergeant Ryan Russell, in 2011 when he ran the officer down in a snowplow. He pleaded the defense of insanity and won, much to the disappointment of Sergeant Russell's family. Mr. Kachkar will be held in custody for a disposition hearing before the Ontario Review Board and will most likely be locked up in a hospital for treatment of his mental illness. His case will be reviewed annually until the board determines that he is no longer a danger to the public.
Some argue that Sergeant Russell's family, as well as the Toronto Police Force, was denied justice in Kachkar's sentence. The problems facing the court was that it was undetermined if Kachkar had intended to kill Sergeant Russell and what Kachkar's state of mind was at the time of the killing. When the verdict was announced, Sergeant Russell's widow spoke against the sentence for Kachkar. Her statements have furthered the issue of victims' rights in these kinds of cases. As Mr. Kachkar's mentally ill rights were upheld in the decision, Mrs. Russell argues that there has been no closure for her and she will now have to fight on an annual basis to keep her husband's killer in confinement, prolonging her pain and victimizing her for many years to come.
In early 2013, Prime Minister Stephen Harper introduced the Not Criminally Responsible Reform Act, which brings about greater justice to the victims of crime. This act will make public safety the absolute main concern of provincial review boards when considering the cases of people who are found not criminally responsible. The act also brings the victims more into the process, whereas they will be notified when and where the accused will be discharged.
First, this legislation directs that when provincial review boards are dealing with persons found not criminally responsible, henceforth, the safety of the public must be the paramount consideration.
We suggest a solution where the accused serves the sentence appropriate for the crime committed if the person were not mentally ill, but as they are found not criminally responsible, their sentence is deterred to be served in a mental institution instead of a regular prison. Their case would not be reviewed annually, eliminating time and money-consuming processes.
Being able to use the defense of not criminally responsible may benefit those who actually require the rehabilitation, but it can also be used as an unjustified loophole in our justice system. Using this defense allows those who commit the crime to serve a lesser sentence and are put in a care facility rather than a prison. This defense should only be used if the convicted are willing to spend the appropriate amount of time to recover, depending on the respective crime committed. If released when they please, who's to say they can't recommit a crime? Our justice system focuses not only on rehabilitating people and integrating them into society once more, but also focuses on the safety of the public, and if a dangerous offender is released into society on an impulse that they are fine, then our justice system isn't serving its purpose. Through the case of R.V. Chalk, we were able to show how this defense is a flaw in the Canadian justice system.